Hello, San. Good morning, everyone. My name's Helen McIntosh, and I'm the president of the South East London Chamber of Commerce. We're delighted. This is our first webinar of 2023, and we're delighted to be back with Thackeray Williams, who many of you will have attended last year's, and I think the year before we were doing webinars with Thackeray Williams. But we've got a very, very topic today. And our topic is cohabitation, prenuptial and postnuptial agreements. And Stuart Ruff is going to talk us through it. Before we start, I'm going to ask everyone to keep any questions till the end. And we don't, as a chamber, we disabled chat a long time ago because everyone flogs their wares that invariably has no relation to the subject we're discussing. So if you can put at the end, if you can put your little yellow electronic hand up to ask your question, we'll be fine. And I think that's all I have to say. So I'm going to hand over to Stuart Ruff, and we're all ears, Stuart.
Excellent. Thank you very much indeed, Helen. I hope everyone can hear me okay. Charlie, could we have the first slide, please? Excellent, thank you very much. Well, morning everyone, and thanks very much for coming along to this this webinar. And if we could then just do the next slide, please, Charlie. That's me. I'm Stuart Ruff. I'm a partner and head of the family law team at Thackeray Williams, and I specialise in all areas of family law, but with a particular emphasis on the financial arrangements arising from relationship breakdowns, whether or not people are married, and also what steps can be taken at an early stage to protect wealth. So we shouldn't just be thinking about what happens when it all goes wrong. And the main point of this talk is about wealth protection as much as trying to unravel things at the end when it's potentially a bit too late. And the main focus of this talk is about prenuptial agreements. And they often get a lot of media coverage when famous people get married or separate. And the reality is that couples getting ready to marry frequently don't want to consider what might happen if the marriage ends. It's not particularly romantic, and a lot of people just don't think that it will happen to them. But the reality is about 40% of all marriages end in divorce. The last set of statistics from the Office for National Statistics, I think it was 42.3% of marriages ending in divorce. Rather counterintuitively, over the last few years, divorce rates have actually fallen, but that's mainly because of an increase in people who live together, and also the pandemic, of course. And a lot of what I am going to say about prenuptial agreements also applies, in essence, to cohabitation agreements as well. So for the purposes of today, we can essentially treat them as broadly being the same kind of thing. It's just that a prenuptial agreement is done in anticipation of a marriage. A cohabitation agreement isn't necessarily in contemplation of a marriage. It's just when people are going to live together, but they still want to sort out and specify what the financial arrangements are. But as with anything in life, preparation for a worst case scenario is very important, and marriage is no different. So starting at the very basic position, what is a prenuptial agreement? Well, a prenuptial agreement establishes the property and financial rights of each spouse should the marriage end in divorce. And it's perhaps useful to think of a prenup a bit like estate planning or an insurance policy. You know, people make wills because they want to leave specific things to specific people. And a prenup essentially does the same thing in the sense that it allows a couple to determine who gets what in the event of a divorce. And because it's being done at the beginning of the process, it enables people to approach it with an objective mindset. And that's obviously very helpful in trying to sort things out. But to actually understand what prenups mean and how they work in practice, I'm actually going to start with one of the most famous openings in English literature, rather surprisingly. Charlie, could we have the next slide, please? Thank you. You'll recognise that as Pride and Prejudice by Jane Austen, and I'm sure if you're the same sort of vintage as me, you'll recognise the BBC adaptation picture there of it. It opens with the words, "It is a truth universally acknowledged that a single man in possession of a good fortune must be in want of a wife." Now, literary types and or cynics will tell you that the opening's a bit ironic and the opposite's true. But bearing in mind the storyline, I think that can actually be taken literally. The necessity of marriage in order to produce a son and heir and keep the family fortune within the immediate family. And that opening sentence also offers a bit of a miniature sketch of the entire plot, which, of course, anyone familiar with it concerns itself with the pursuit of single men in possession of a good fortune by various female characters, which suggests that the reverse is true. A single woman looking for a socially advantageous marriage to provide financial security and status. Now, of course, things have moved on a lot since Jane Austen wrote Pride and Prejudice, and at that time, divorce was very rare. And actually, it required an act of parliament in order for a divorce to occur. But what the story of Pride and Prejudice does is it highlights the importance of getting married and marrying well. But it also highlights the problem where an estate is involved in the marriage and the family. And at that time, only a son could inherit. And of course, for Mr. Bennet, that was a bit of a problem because he had 5 daughters. So the legal position and the trust position actually form an important backdrop to Pride and Prejudice. So what's not actually changed since Jane Austen's time? Well, firstly, everyone hopes for a long and happy marriage. Secondly, a well-drafted trust or agreement, prenuptial agreement, can still prevent disposal of assets and income to certain people. And then finally, sadly, we still have to pay tax on the land and buildings that we occupy. But there have been lots of things that have changed since Jane Austen's time. A wife is no longer a chattel. Because before 1870, believe it or not, any money or property that was owned by a woman through working, gifts or inheritance actually became her husband's property on marriage. And it took the Married Women's Property Act of 1870 to change it. And then in 1882, a further act, also called the Married Women's Property Act, extended it to all property, regardless of the source or the time of its acquisition. So women were actually able to own property in their own right, rather than it passing to the husband. Divorce now, unlike in Jane Austen's time, is much easier and doesn't require an act of parliament. There's also no stigma attached to divorce now, as there was back then. And admitting you've got problems in your marriage and are seeking help is actually quite commonplace. When a divorce occurs, we're governed by something called the Matrimonial Causes Act. And within that act, there is a checklist of what the court has to take into account when deciding how to divide up matrimonial assets and liabilities. And the needs of each party and what is fair are the key driving forces behind the consideration in dividing assets. Things like contributions, inheritances, and things like that very much take a back seat to the needs and fairness arguments. A divorce court can also now share and split pensions. And on a relative scale, we're paying much more tax than we were back in Jane Austen's time. And this has led to all sorts of clever and sophisticated plans being put in place to reduce the amount paid, which often involves passing assets to the next generation before death. And one of the things that I find doing this type of work is that there's a lot of misconception about what the law actually is. There are still many people out there who think that there is such a thing as a common law spouse, and that after a period of time, rights equal equivalent to married couples are magically acquired. That's just not true. You're either married or you're not. There is no concept of common law spouse. Another misconception is that there's an automatic 50-50 division of assets on divorce. Actually, that's not always the case at all, because in order to be fair and meet parties' needs, particularly if those parties have unequal income and assets, etc., you might actually need to give one person more than 50% of the assets in order to achieve an overall equal outcome. But ultimately, each case is decided on its own facts. So the question then is, well, what if you've got money, or you're anxious to protect and preserve money or assets for the family further down the line, rather than seeing it disappearing in divorce proceedings? That's often where a prenuptial or a postnuptial agreement comes into play, because that can restrict what the economically weaker party could get. And the courts now, for reasons I'll explain in a few moments, pay a great deal of attention to the content of a prenuptial agreement, provided it's been properly entered into. Lifelong spousal maintenance orders from the court are now very much out of fashion, and the courts are much stricter in applying a fixed term period for any spousal maintenance that might be payable. And as a general rule of thumb, the test is, how long do we think it will take the receiving party to become financially independent after divorce? And generally, if you haven't inherited from your parents at the time of a divorce, you don't take it into consideration, because you can't take away what you haven't got, and you can't take into account that you might receive an unknown amount of money at an unknown point in the future. Lots of people think that if their spouse has got wealthy parents, that will help them achieve a bigger settlement in divorce, but that's not going to apply unless the parents have a track record of giving money during the lifetime and prior to the divorce. But even so, you do still need to be careful before any assets are gifted in the hope of reducing a tax bill on death, because going through a divorce can sometimes be more expensive than the HMRC. So with that little bit of background, we can then move on to prenuptial agreements and what they are and where we are with them legally. Because I'm sure lots of people have heard of them generally and might have heard either they're not worth the paper they're written on, or alternatively would have heard the opposite, that actually they're done and dusted and that's it. But it's important to remember that the family courts operate on a discretionary basis, and the individual judge has a very wide discretion as to how to split assets and liabilities on divorce. But the first consideration, as I mentioned a bit earlier, is that any such division has to be first and foremost fair and meet the parties' needs. That is the primary aim. Prenuptial agreements often were not considered to be fair because they were very heavily weighted in favour of the person seeking to protect a particular asset or the wealth. And until 2010, so what, 13 years or so now, prenuptial agreements were just something that the court should be aware of and take into consideration, but it was up to the individual judge to decide how much weight to attach to the prenuptial agreement. And in most cases, the answer to the question, how much weight should a judge give to a prenuptial agreement, was not much. And often judges would just look at them and go, oh, there's a prenuptial agreement. That's nice, but I'm still going to make my own mind up. But in 2010, there was a case, and it got an awful lot of media coverage at the time. And unfortunately, the media coverage rather misrepresented the exact details of it, because the media presented it that prenuptial agreements were actually legally binding. And it's not quite true. But this case in 2010 was called Radmacher and Granatino. And that changed the landscape of how the law treated prenuptial agreements. And it essentially switched the emphasis of how the courts should view a prenuptial agreement from being a discretionary exercise of how much weight to give to an agreement to one looking to uphold an agreement. The court actually said in that particular case, the court should give effect to a nuptial agreement that is freely entered into by each party with a full appreciation of its implications, unless in the circumstances it wouldn't be fair to hold the parties to the agreement. So we've gone from a position where courts really wouldn't pay prenuptial agreements a great deal of attention whatsoever, to basically one of now saying, well, why shouldn't we uphold it? So it's not gone as far as to make them legally binding, but what it has done is it's shifted the emphasis to basically say, here's a prenuptial agreement. Is there a reason why we can't follow it? And if a prenuptial agreement is done properly, it is very difficult to argue in front of a court that it shouldn't be upheld and followed in terms of what it provides for. So who benefits from such an agreement? And broadly speaking, we've got three categories. Charlie, could we have the next slide, please? Thank you. So the first category is usually people who are on second marriages or marrying later in life. The next slide, please, Charlie. Oh. Thank you very much. You've then got the wealthy, and then the next slide, please, Charlie. The likely to be wealthy. So we've got those three categories, usually. Not always, but usually people will fall into one of those three categories. So if you are thinking about doing a prenuptial agreement, what do you need to do? Could we have the next slide, please, Charlie? Following on from that case of Radmacher in 2010, the Law Commission set out some tips, if you like, that should be followed as a matter of good practice to create the strongest possible case for a prenuptial agreement to be upheld. So firstly, the agreement should be signed at least 4 weeks before the wedding. And frankly, the earlier the better. This is to avoid any allegation that one party is being forced to sign it with undue pressure being exerted and being given an agreement very close to the wedding, or possibly even on the eve of the wedding, and being told to sign it, otherwise the wedding is off, often leaves the other person with little choice, regardless of what the agreement may say. So the first thing is to make sure that there is no pressure being put on people to sign the agreement. And it's interesting that in America, they actually video the signing of prenuptial agreements, because that can then be used to show the demeanor and the willingness of the participants in the event of a dispute. Now, we haven't gone that far here, but it's interesting that that's how they deal with it over there. But here, it should be at least 4 weeks. And it never ceases to amaze me how late in the day people leave it before they contact me saying that they want a prenuptial agreement. Often it will be within 4 weeks of the date of the wedding. And they'll say, we're getting married this time next month. Realistically, you should be thinking about a prenuptial agreement, if you're going to do one, pretty much as soon as marriage becomes a likelihood. But in terms of actually consulting a solicitor about it, as I say, the earlier the better. But in reality, you're probably looking at least 5 months before the wedding, because that allows for time for it to be negotiated, drafted, agreed, and then signed no later than a month before the wedding. And if you're going to have one, for obvious reasons, it's also a good idea to raise the issue with your fiance in good time before the wedding. So the first criteria, condition, if you like, is the timing, at least 4 weeks before the wedding. The second recommendation by the Law Commission was that both parties have to make full and frank disclosure of their respective financial circumstances. Because if someone's looking to protect their assets, they need to be transparent about what those assets are that they are looking to protect. And likewise, if someone is being asked to give up their claim against a particular asset, they need to know what it is they are being asked to give up. Thirdly, the Law Commission said that both parties have to take independent legal advice on the agreement, and they must have an understanding of the nature and the effect of the document that they are signing, and therefore the rights that they are either acquiring or relinquishing under the document. And those conditions, the timing, the full and frank disclosure, and the independent advice, are usually satisfied by including appropriate clauses into the prenuptial agreement itself. So it's all a one all-encompassing document that makes it abundantly clear that the agreement is being signed freely, voluntarily, without undue influence. The document is obviously dated, etc. So it's amalgamated into the document. Could we have the next slide, please, Charlie? Thank you. So, having dealt with what we need to do to give an agreement the best chance of being upheld by the court, we obviously then come on to the next logical question is, what can a prenuptial agreement actually say? And quite simply, providing the terms of the prenuptial agreement meet the needs of both parties in the event of a divorce, because remember I said earlier, the first consideration is meeting the parties' needs and fairness, but providing the agreement does that, then you can essentially say what you want and you can cover what you want in an agreement. But there are obviously pros and cons with that, because, for example, you can make provision for children and that provision can be quite specific, or you can simply say that provision for children will be determined at the time of the divorce. So on the one hand, you can make specific provision. On the other hand, you can effectively kick the can down the road and say, well, we know we've got to make provision for the children, but we'll deal with that at a later point. Likewise, you can be specific about how certain assets will be dealt with on divorce, or again, you can say that we'll deal with this particular asset at a later date. So you can effectively pick and choose how encompassing or otherwise you want the agreement to be. You might only want the agreement to reflect or relate to one particular asset, maybe let's say an inheritance, for example, because you want to ring fence that effectively. So you're only dealing with the inheritance, one issue in the agreement, or alternatively, you can deal with everything and be very prescriptive about everything, so that there is then nothing to then have to come back and renegotiate at the end of the day. You can also specify, if it's a case where there might have to be spousal maintenance, you can specify the amount of maintenance that will be paid on a monthly or an annual basis, and also the period of time over which it will be paid. Likewise, you can also make provisions for assets to be put into trust for a particular reason. Now, of course, you need to be careful about that, and you then need to take the appropriate advice about trusts and tax and all the rest of it. But that can be done. And of course, one of the main risks with doing that is that tax rules in the future might be very different to the rules at the time the agreement is made. So, but that's an example of what you might want the agreement to cover. But as I say, and as I have said a few times already, the key words in any divorce are needs and fairness. So essentially, a prenuptial agreement can say and provide whatever you want it to, provided it meets the needs of both parties and it's overall fair. And if it meets the needs and is considered fair, a judge is going to be very slow to interfere with it. And obviously, nuptial agreements are bespoke documents, because no two parties' financial situations are the same. But usually the agreement will identify the assets and the liabilities that each party is bringing into the marriage, and then specify how those assets and liabilities are going to be divided on divorce. And it will also include any assets that the parties will come into possession of during the course of the marriage, even if those assets aren't actually in existence at the time of the marriage. Because, for example, you've obviously got the question of an inheritance, but you might also, at the time of the marriage, just have one property. But during the course of the marriage, you might then buy a second, third, fourth property, etc., and build up a little portfolio. And a nuptial agreement can say how any future property will be divided. Either, for example, it'll be divided equally between the parties, or alternatively, it will be divided in proportion to the respective contributions that the parties have made to its purchase price. So prenuptial agreements are very wide-ranging documents that can cover, frankly, as many circumstances as you want it to and can envisage. But of course, with these documents, life moves on, things change, and no one can gaze into a crystal ball. You might make an agreement before you marry, but within a few years of marriage, you might then have children. And of course, a nuptial agreement made before the marriage won't necessarily make any provision for children that come along or other changes in circumstances. So it might be fair at the time it's entered into before the marriage, but a few years down the line, it might not be fit for purpose anymore. And as a result, most nuptial agreements will contain a review clause saying that the agreement will be reviewed after maybe 3, 4, 5 years, or perhaps the birth or adoption of a child. Because if you don't then review the terms of the agreement, and there is a change in circumstances, obviously that's then likely to have an impact on the fairness of the agreement and the agreement's ability to meet the needs of the parties. So a review clause is very important in these types of agreements. Could we have the next slide, please, Charlie? Thank you. So a little summary of what I've just said. First of all, should I get a prenup? Is it for me? Well, the reality is that if you're asking yourself, do I need one, then you probably do. And realistically, it may very well be worth any early discomfort to then benefit from the value of having the prenup later down the road. They're also actually being viewed increasingly now as a way of actually fostering trust and open communication between partners about finances. And as I've said, they can be particularly useful to couples who want to keep significant pieces of personal property separate and on their side of the balance sheet, so to speak. And that's common for both people. Even if one person is wealthy at the time of the marriage and the other one not so much, the other person might come into an inheritance, thus making them either just as, if not more wealthy than their spouse. So it can deal with those things, the inheritances, other anticipated incomes. And that's why it's often used for people who are on second marriages or marrying later in life, because of course, assets have already been built up from previous work, marriages, etc., that you want to protect in the event of a second marriage. They're also not just for the uber wealthy. There is this misconception that a prenup is only applicable for wealthy people. That's not always the case, though. People with modest means can also find value in a prenup because there will still be things that they might want to protect. And also, they don't want the emotional damage of having to have an argument about how finances are dealt with in the event a divorce occurs in the future. So it isn't just for the wealthy. It can benefit anybody. You can obviously protect family heirlooms, and that if the marriage does end, you get to keep the item so that you can then pass it on as you so wish without fear that it will pass to the other side of the family on divorce and then disappear down that family's tree line. It passes property to children from prior marriages. If you've got children from a previous marriage, you obviously want to ensure that they get what you want them to get, rather than it potentially going across on divorce to your ex-spouse, and then that spouse then leaving it to their family. I think a very famous example of that occurred to John Cleese. And that got a bit of media attention because on one of his divorces, a lot of his assets passed to his ex-wife, and she was then able to leave it to her side of the family, meaning that his side of the family didn't get, or there wasn't available to give to them, anywhere near as much as he was hoping to. It provides certainty and it clarifies financial rights between the parties. And it enables people to actually make the decision for themselves as to what happens, rather than putting it in the hands of a judge to make the decision for them. It can also help with debt protection, because that also goes hand in hand with clarifying financial rights, because some people enter into marriages with significant debt or other liabilities, and a prenuptial agreement can be used to clarify whose responsibility that debt will be. Now, the parties obviously have the freedom to agree between themselves how they want to do that. The other spouse might say, well, it's okay, I'll help, it's not a problem. But equally, the non-debted spouse might think, well, I don't really want that. So the nuptial agreement will be able to say the liabilities remain on that side of the balance sheet. It also helps you avoid emotional arguments. Because you have dealt with everything early, when everything is okay between you and going well, you're able to enter into it with a clear mind, without the raw emotion of the marriage having broken down and having to then argue and all the rest of it, because it is a completely overwhelming and upsetting process. So whilst having a prenup won't take away the emotion and the upset and all the rest of it, what it at least does do is it provides certainty as to what both parties are going to exit the marriage with, rather than having that uncertainty about, well, what am I going to get? You've cleared that up. And it's obviously a lot cheaper to deal with it and get a prenuptial agreement drafted before the marriage than having to employ lawyers and then potentially invoke the court process to divvy up the matrimonial assets and liabilities. And of course, matrimonial proceedings are essentially self-funding, by which I mean the lawyers get paid out of the matrimonial assets in some way, shape or form, whether it's out of income, investments, sale proceeds of a house. And putting it bluntly, the more money people spend on lawyers, the less they then have to divide up between themselves. And it's better in their pockets than it is the lawyers' pockets. You're probably surprised to hear me say that, but that's the reality of the situation. It is. So the less you spend on the lawyers, the more of the matrimonial pot you actually have to split between yourselves. And of course, avoiding these arguments at the end does help foster a good chance of a decent relationship being maintained between the divorcing parties, which of course is particularly important if you've then got children together and you then need to carry on co-parenting them for however long it is. A very quick word on postnuptial agreements. But much of what I have said about prenuptial agreements, as I said at the beginning, can apply to postnuptial agreements as well. Essentially, a postnuptial agreement is an agreement that is done after the marriage rather than before the marriage. Now, if you have reviewed a prenuptial agreement because of, let's say, a birth of a child or something like that, any amendment to the prenuptial agreement would essentially be a postnuptial agreement because it's a new agreement that's being entered into after the date of the marriage. But again, irrespective of whether it is a prenuptial agreement or a postnuptial agreement, the basic requirements remain. It needs to be fair. It needs to meet the needs of both parties. There needs to be the full and frank financial disclosure. There needs to be the independent legal advice. But of course, you're not then under the same time pressure to make sure that it's signed at least 4 weeks before the wedding, because of course you're already married. So the timing pressure and the duress argument is obviously a lot less acute than it could be with a prenuptial agreement. Postnuptial agreements also potentially are a little more sensitive, because if you didn't have a prenuptial agreement going into the marriage, what has suddenly changed during the marriage to make someone decide that they want an agreement asking their spouse to give up certain rights in the event of a divorce? So sometimes postnuptial agreements in isolation can sometimes be a little bit more sensitive for that reason. And my experience is that postnuptial agreements in their own right are actually pretty rare. And even when they are floated as an idea, it's not uncommon for the other person to refuse to sign it. Because, of course, irrespective of whether it is a prenuptial or a postnuptial agreement, the key word with it all is agreement. If there isn't an agreement, you obviously can't have a document such as that. I appreciate that's been a little bit of a canter through in a fairly broad brush sense of prenuptial agreements, and the issues raised in this are fairly numerous and complex. But if anyone's got any questions that they'd like to ask now, then I'll be more than happy to field those. Or alternatively, if you'd like to get in touch with me afterwards and separately, then again, please feel free to do so. But thank you.
Thank you very much, Stuart. Charlie, can you take the slide down, please? Lovely, thank you. Now, do I see any little yellow hands? Or a hand? Yogesh, then John.
All right, if I may, Stuart, the question that I have for you, does that mean that you cannot have a postnuptial agreement if you don't have a prenuptial agreement? Is that...
No, Yogesh, not at all. You can have a postnuptial agreement. Absolutely, you can. And the considerations for a postnuptial agreement are exactly the same as they are for a prenuptial agreement. As I say, the only reason they tend to be rarer than prenuptial agreements is because you're then suddenly saying to your spouse, almost out of the blue, I now suddenly want you to give up your right in respect of X, Y, and Z. And that can obviously create a little bit of concern, because if you were on the receiving end of that, you might think, well, why are they doing that? Are they thinking about a divorce and they're asking me to sign away my rights in respect of something? Whereas if, of course, you've had a prenuptial agreement that provides for a review after a period of time, or birth, adoption of a child or something like that, it's then a logical process, because that's how you've decided to organize your financial affairs, essentially through a series of agreements that says, if we divorce, this is what's going to happen. Whereas if you're then suddenly presenting someone with a postnuptial agreement several years into the marriage, that might cause more trouble than it's actually worth. So you can absolutely have a postnuptial agreement without having gone anywhere near a nuptial agreement before the marriage. It's just they are less common.
Sure. Thank you.
Thank you. And we'll take a question from John, and then we'll go on to Ingrid. John.
Hi, thank you very much indeed. That's an excellent presentation. One question, you were talking throughout it with regards to divorce, and I'm considering prenuptial agreement to secure assets on death of both parties. In a marriage, a new marriage. So on a new marriage, we want to go into it securing our own assets, which we have.
Yeah.
And how that's going to be split on death.
Yeah.
Of one part.
No, absolutely. So, I mean, you know, you'd be absolutely right to be thinking in terms of a nuptial agreement in those circumstances. Excuse me. And what a lot of prenuptial agreements say, whilst, of course, there's no, you know, sort of right answer and they're not all saying exactly the same thing, but it's not uncommon for prenuptial agreements involving second marriages or later life marriages basically saying, look, this is what I'm bringing into the marriage, this is what you are bringing into the marriage, and in the event of a divorce, we each retain what we bring into the marriage. And as part of the financial disclosure exercise that I mentioned, you attach to the agreement a schedule of your respective assets and liabilities. So it's just, you know, a couple of pages saying, I've got this property worth this amount of money, I've got these bank accounts with these balances in them, I've got these investments, these pensions, an interest in this trust, etc. Both parties do that. And it's often a case of saying, yeah, this is what I'm bringing in, this is what you're bringing in, and in the event of a divorce, we'll just take out what we've brought in. And particularly if it's a later or second marriage, you've then often got round the point about the fairness and does it meet the needs, because often what each party's got in their own right and therefore is retaining would be sufficient to meet their own needs.
Yeah, I'm talking about if there was a death of one party. So if one party dies, does the surviving partner have a right to those assets if there's no agreement?
Well, of course, if you die, then it may very well be the case that you're not going through divorce proceedings or anything like that, in which case it's the usual Inheritance Act rules. So that would then follow, because of course we're only talking in terms of what happens in the event of a divorce. Of course, in the event of a death where there isn't anything going on divorce wise, then it's the usual inheritance and wills that govern what happens to the assets. Okay.
Would you advise having a prenuptial that would cover that anyway? So that there can be no claim from one party against the other?
Yes, I mean, it's always a very good idea because whilst it's not my area of law, there is something called the Inheritance Act, provision for family and dependents. And I'm aware in very general terms, from colleagues who do this, that you can have a situation where a surviving spouse or person can bring a claim under the Inheritance Act if they have not had adequate financial provision made for them.
Okay.
And what you wouldn't want to have happen, I'm sure, is essentially your executors then having to deal with an Inheritance Act claim.
Okay.
But I stress that is not my area at all.
No, I understand that. It was just... It leads on to an alternative to a divorce, but I mean, there's still that problem anyway. Okay, thank you very much indeed.
Thank you. Ingrid, your question.
Thank you, Stuart. That was very helpful. I don't know if it is me who misinterpreted it. I thought you were going to talk about cohabitation as well. Or did I miss that? That's the first.
No, absolutely. I mean, as I said at the beginning, essentially, the way that I dealt with the talk was what I said about the prenuptials can essentially be translated to the cohabitation agreement.
Okay.
And when it's unmarried people who want to live together, it's essentially the same thing. You just call it, instead of a prenuptial agreement, you basically call it a cohabitation agreement, because what it does is basically set out what happens in the event that that cohabiting relationship ends.
Okay, so if there wasn't a cohabitation agreement and two parties are looking to separate,
Yes.
the one party who has more is willing to give the other something in settlement to move on, is there any pitfalls that one should be looking to avoid at this time?
Well, married and unmarried couples are treated differently under English law. So that's very important to bear in mind, because if you are married, you are governed by something called the Matrimonial Causes Act, which I mentioned earlier in the talk, and that basically gives the law, the courts, the ability to deal with all financial aspects relating to married couples. Unmarried couples have very different financial claims available to them, and for example, unmarried couples have no right to the equivalent of spousal maintenance. There is no requirement in an unmarried scenario for one person to make financial provision for the support for the other person. You do not have the ability to share pensions, for example, if you are not married. And usually the only financial claims that exist between unmarried couples essentially relate to their respective financial interest in the property that they own together. And then if there are children as a result of that relationship, there are some financial claims that can be made on behalf of the children. So a cohabitation agreement is basically the same as a prenuptial agreement, and it can set out who's responsible for what, maybe the division of how the bills are paid, who pays what, etc. But it can also clarify what the respective interests in the property are as between the parties, although that would actually be established at the time the property is purchased and you're ticking the relevant box on the transfer form, the TR1. And it's then very difficult to look behind the TR1 transfer form because the legal title often follows the law follows the legal title. And it's very difficult to argue against that. Where most people end up having an argument is if they have made a financial contribution to the purchase of a property, but for whatever reason, the property is only registered in the sole name of one party.
Okay. I must say, Helen and Stuart, thank you so much. This has been really useful. Stuart, you explained in layman's language. I found it easy to follow. And I love that you put this on for us from the Southeast Chamber of Commerce. So just thank you so much.
Thank you.
Excellent. Now, do we have any more questions? Last chance. Can you see any yellow hands, Charlie?
No.
Nope. Last chance. Well, I'm going to say thank you so much, Stuart. This has been really informative. I'm just going to give a little plug because our next webinar is going to be on Wednesday, the 22nd of February. And this is all about marketing. And you can be able to learn about target your market and the key messages to address to the market. That's going to be given by Sarah Hawes of IZPR. And then on the same day, if you want to go out to Bromley, 22nd again, we've got a link and drink at the Bromley Court Hotel, 5:30 to 7:30. All that means is you come along, you tell us a little bit about yourself, you buy yourself a drink, it's completely free. But our big breakfast, which means it's getting up slightly earlier, you've got to be at the Novotel for 7:30, on Thursday, the 16th of February, when we're going to hear the leader of the Royal Borough of Greenwich, Councillor Anthony Okereke, talk about his plans for the borough. So I'm hoping everyone who's a Greenwich, works in Greenwich or the surrounding boroughs, please come to Novotel. So that's it. And Yogesh, we're going to find a date for you to talk about all about tax. Thank you, Chartered Accountant. And I know that there will be more legal webinars coming up a bit later in the years with Thackeray Williams. And thank you so much, Stuart. It's been really good. Thank you.
Thank you very much, and thank you for everyone listening to me and for your subsequent questions. Thank you.
So interesting. Thank you. Bye-bye, everyone.
Bye-bye.
Thank you.
Good. Thank you, Denise. Wasn't it interesting? So we've got, who have we got? We've got everyone going. There we go. If you stay here, Charlie. So I think everyone else